मिस्टर सलाउद्दीन हियर, ये देखिए जो बुराइयां आप बता रहे हैं एनेबलिंग कंट्रीज में सब जगह हैं, क्या इन सब को रिमूव करने के लिए पार्लियामेंट ने इंटरवीन किया है या कोई दुनिया में ऐसी मसाल है कि प्रैक्टिस एंड प्रोसीजर ऑफ कोर्ट के हवाले से कोई लेजिस्लेशन भी हुई है कहीं?
My lord, in various jurisdictions there has been.
कोई एक किसी मुल्क का बताइए जिसमें प्रैक्टिस एंड प्रोसीजर के हवाले से कोई एनेक्टमेंट आया हो?
My lord, in various jurisdictions, for example, in the United Kingdom itself, practice and procedure of the UK Supreme Court is done
Yes.
by the UK by an act of Parliament. Now, interestingly, in India, one of the Chief Justices who held the press conference, one of the judges who held the press conference against the Chief Justice, Justice Raman Gogoi, he himself became Chief Justice.
I was wondering when you would come to that. That's the most interesting part.
And when he became...
Mr. Salahuddin Ahmed, we became independent in 1947. We can learn from other countries by all means. But whilst we refer to Indian judgments quite generally in all our judgments, I've never seen it reciprocated in India. Have you ever come across an Indian Supreme Court judgment or any High Court judgment which has ever referred to a judgment of Pakistan?
But I think there are some very early ones, but no, not of late at least.
I'm just saying this perpetual fascination with what happens across the border. Why can't we just stick to our constitution, their constitution? We've seen what they've done with their constitution. I don't know how they're going to decide Article 370. Let's see the independence of the judiciary there. Let's not put that as the benchmark for the best what happens in the world. Let's stick to our own thing. They are welcome to theirs. Let us be guided by our own lights. I mean, we're not looking to Islam. I mean, that is brushed under the carpet. We're looking to India, we're looking to the US, and when anything Islamic comes up, the constitution starts with the word. Islam mandates the right of appeal. Even the Almighty does not condemn without having heard. And why we are not going by our traditions at all? I mean, just everything Indian, everything. Then they don't even reciprocate. I mean, fine, they don't need to. That's up to them. But why are we so beholden always?
I'm saying the opposite, sir, in fact. I'm saying that one should also learn from the mistakes of our neighboring jurisdictions, not just from their judgments. And that is why I was pointing out, sir, that Justice Raman Gogoi, when he became Chief Justice, the bar went to him and said that now reform the powers of the Chief Justice. He refused, and then there was a sexual harassment petition against him, and he fixed it before himself and dismissed that. So the Indian citations, I agree with your lordship, are to be taken with a pinch of salt. Now, a similar situation, sir, arose in Nepal. And I do think, sir, that when we are looking at foreign examples, perhaps relying upon US and UK jurisdictions itself might not be so apt for our socio-political economic realities. We should look at countries closer to us.
So we are taking a poll of the countries in the world.
Not at all, sir.
I mean, 200 countries do this, we must do it, or vice versa.
It is a reflection of the same problem that has arisen elsewhere.
But to your knowledge, I mean, before you move on to Nepal, in India, up to now, has Parliament then stepped into the breach?
No, sir. No.
Thank you.
Mr. Salahuddin, whether the constitutional convention...
Does that mean our Parliament is more vigilant?
Yes.
You just say no, I mean, you don't expand anything further.
My lord, I agree that our Parliament has acted because there was a vacuum.
I'm still waiting in all of this to get to
the constitutional competence. Yes, sir. I'm coming. I'll be there, sir, very shortly.
Mr. Salahuddin,
Nepal and Bangladesh and
very shortly, sir. Just two more submissions on this regard and I'll move on.
Don't forget all these. Very important.
Kindly, the Constitutional Convention, does they have the status of constitution? Can they be changed in accordance to the coming situations? Or if it can be changed, who can change it? Whether convention is fixed, it cannot be changed.
My lord, that is exactly the difficulty, as I understand it, of constitutional conventions. Because if you have a position that the constitution says that this power belongs to A, and then the framers of the constitution amend that and they say this power no longer belongs to A, how can it be imported that the Constitutional Convention still continues to empower convention.
That is not a convention. That is where that situation would arise if, for example, in the 62 Constitution or the interim or 73 Constitution, there were words to the contrary. All that those, as I understand it, but subject to any correction from your part, those constitutions, and including the present one, has structurally gone to the position of the Government of India Act. And therefore, the case law that has come up has come in the context of the 1973 Constitution. What I'm saying is that there's a background to that case law. It's not something that in 1979 was said for the first time. The conventions go back decades, if not centuries. That's what.
Malo, I'm grateful for your lordship's observation. Now, I just moving on to
Mr. Salahuddin here. ये देखिए जो बुराइयां आप बता रहे हैं एनेबलिंग कंट्रीज में सब जगह हैं, क्या इन सब को रिमूव करने के लिए पार्लियामेंट ने इंटरवीन किया है या कोई दुनिया में ऐसी मिसाल है कि प्रैक्टिस एंड प्रोसीजर ऑफ कोर्ट के हवाले से कोई लेजिस्लेशन भी हुई है कहीं?
My lord, in various jurisdictions there has been.
कोई एक किसी मुल्क का बताइए जिसमें प्रैक्टिस एंड प्रोसीजर के हवाले से कोई एनेक्टमेंट आया हो?
My lord, in various jurisdictions, for example, in the United Kingdom itself, practice and procedure of the UK Supreme Court is done by the UK by an act of Parliament. If the effect and the substance of that law is to impair in any manner the access to justice, then it's a different issue.
thing.
But legislatively, they can.
They can do that.
They can. Now, my lord,
Mr. Salahuddin, please read section 2, subsection 2. Please read that of the act, which
Jeez.
is impugned before us.
सर अगर इजाजत दें ये वाला लेग खत्म करके फिर मैं वो
Please, ये जरा पढ़
जी मैं पढ़ लेता हूँ सर, पढ़
इसी
लेता
के साथ related है,
हूँ जी
इसलिए
सर,
आपसे पूछ-
मैं अभी पढ़ लेता हूँ सर. Section 2, subsection 2, soon after commencement of this act, the committee constituted under subsection 1 shall hold its first meeting to determine its procedure.
बस यहाँ पे
जी सर.
if suppose this enactment succeed, the again procedure has to be constituted by the committee.
Yes.
So the same procedure, which is the brainchild of 191, again has to be exercised by the committee. So the definition of Supreme Court, that so Chief Justice and judges would not compromise.
My lord, as far as I understand the
You
word,
see, in the spirit of 191, the whole the court is supposed to make the rules, but here only there are 3 persons to make rules. What do you say about this?
ji sir, as I read section 2.2, when they talk about procedure, they are not talking about the procedure of the court. They are talking about the procedure of the committee, how it will hold meetings,
Yes, of
how
course,
it will
of
do that.
course.
So that power is not about the procedure of the court mentioned in 191. That is an internal arrangement of that committee to decide how often we will meet, whether it's every week or once a month or what, so on and so forth. So
But how
that
do
does
you-
not impact.
How
the
do you
191.
determine that this is an internal matter for the Supreme Court to decide, as opposed to this is a matter which can be legislated on? As per your argument, once it is legislated upon, they have competence, they can legislate. The Supreme Court then cannot make any rule contrary to that. So they can make whatever, wherever they want to legislate, they go ahead and do so. But how does one then determine that this falls within the internal matters of the Supreme Court, hence no legislation, and this doesn't fall within the domain of the internal matters of the Supreme Court, hence you can have legislation? I mean, you just seem to be placing more conditions than you are in explaining how you're giving competence in a simple way. हर चीज को आप कंडीशन करते जा रहे हैं कि ये फिर ऐसे देखा जाएगा फिर ऐसे, तो that surely can't be the purpose and intention of the constitution.
Mr. Salahuddin, there are 2 things. This section 3 and section 4 is actually dictating the Supreme